I think that during Boris Johnson's prime ministership, there was a contempt for Parliament, which was very unfortunate. The test of a functional parliamentary democracy is not whether it stops complete charlatans from getting to the top.
Are you saying he is a complete charlatan?
Yes. I really don't see that the Strasbourg court, which is a very ideological court, is going to reform itself. I once thought that there was some prospect of that, but I've given up on that.
This is The Judges, Power, Politics and the People, hosted by the University of Law. This week, I'm speaking with Lord Sumption. Jonathan Sumption broke ground when he was appointed as a Justice of the Supreme Court in 2012, the first appointment to the top of the judiciary to be made directly from the practising bar. As a barrister, he'd carved out a highly successful career with wide-ranging expertise spanning commercial law, constitutional law and human rights, and appearing in many complex and prominent cases. He was famously once described as having a brain the size of a planet. A historian by background, he has written several books, notably a 5-volume account of the 100 Years' War. On retiring from the Supreme Court in 2018, he became a prominent public commentator and writer, expressing often controversial views, such as on the handling of the COVID-19 pandemic. In 2019, he delivered the Reith lectures for the BBC on the theme of law and the decline of politics. I began by asking Lord Sumption whether former judges should speak out on matters of public debate.
It depends on the subject. I think that there is absolutely no reason why former judges should not discuss legal issues, many of which will be issues with political implications. That's the way with the current state of the law. There are many cases that the courts hear which have significant political consequences. I don't think that that means that the judges who decide them are political, but it does mean that they may have to speak out on what they think that the law is. So I have no problem, and I don't think anyone else has any problem, about speaking out on legal issues, on constitutional issues in the broadest sense of the word. That, in my case, would include free speech, for example, which I feel strongly about. There are other issues, like COVID, on which I think that in principle, judges should not speak out even after retirement.
You have, of course, haven't you?
I have, yes, and the reason for that is that I think that there are exceptions to every rule. My view about the lockdowns was that it had really very significant implications for the relationship between the state and the citizen, which were likely to last very much longer than the pandemic. I thought that that was a source of real concern, and I think that you always have to say that there are some issues which are so fundamental that they are much more important than any convention about what a judge should or shouldn't say after retirement. I thought that this was such an issue. And I think that on those issues, you have to stand up and be counted.
And of course, that aside, it does, speaking out generally, as you say, because of the decisions, the kind of decisions judges make now, it does mean treading deeper into political waters. Is that okay as a former judge?
It shouldn't do. I mean, if you're talking about a politically controversial decision, like, for example, the two Gina Miller decisions in the Supreme Court, there is no way that you can discuss that and keep the politics out of it. But there's no reason why a former judge's opinions should discuss the politics at all. There's no reason why, by saying, for example, that the prorogation decision was right, as I think it was, you are necessarily endorsing remaining or the opposite. There is a world of difference between saying we ought never to have left the EU and saying the prorogation decision was a perfectly sound decision, regardless of the Prime Minister's reasons for proroguing Parliament.
And do you think, and I've heard you speaking on this before, but do you think judges can actually leave their politics at the door of the court?
Yes, they do it all the time. There's a lot of public law, particularly in the Supreme Court, and I know from personal experience that they leave their politics at the door. That's not actually very difficult for most issues. You know, if the issue is a judicial review of an administrative decision about immigration or education, etc., you can perfectly easily decide that without having any particular view or without expressing any particular view about the merits of immigration. That's just one example, and by and large it's true across the board. I mean, the two Gina Miller decisions touched a very raw nerve because some people believed that they had the capacity to derail the whole process and felt very strongly about it, and it was very difficult to persuade them that the Supreme Court wasn't making a political decision. But actually, I know what the views about Brexit are of pretty well all my former colleagues, and I'm not going to tell you what they are, but I am going to tell you that they bore no relationship to the difference between dissent and assent in the first Gina Miller case, or the views expressed by a unanimous Supreme Court in the second one.
You've touched on the Gina Miller cases, so let's chat a bit about that now. Mm-hmm. You say you knew what the political views of your colleagues were, but they didn't come to bear on the ruling. No. I think some people were surprised about the decision you took in the first one that you sat on.
Why should they have been surprised about the decision that I particularly took?
I think people suspected that you would be in the minority there.
Well, they had no reason to suspect that. They didn't know what my views were on the constitutional issue. I'd never expressed them before, and in some ways I'd never had to think about them seriously before this case.
And what's your view about the unanimity in the second ruling involving the suspension of Parliament? Was that a surprise to you?
No, not particularly. I think that may have been, I mean, obviously I'm not privy to the way that the deliberations went, but I think that it may have been because of the particular ground on which the government lost, which in my view wasn't the most satisfactory ground. It may be that the more satisfactory ground would have been more controversial within the court. But let me explain what I mean. The government grossly mishandled the whole case. What they should have done, if they wanted to put their best foot forward, was to go in saying, well, everybody agrees that it is the function of the government and not of Parliament to negotiate with the EU. It's a very delicate diplomatic situation. We cannot be expected to have a successful discussion with the diplomats of the EU if we have all this background noise in Parliament undermining our negotiating position all the time. That's what, in my view, they should have said, and there would have been a reputable case for that argument. Instead of which they said, oh, this has absolutely nothing to do with negotiations. It's all a matter of efficient time management. They felt they had to say that because Boris Johnson had sent a circular announcing his decision to prorogue to all members of Parliament in both houses, and that made this claim, which was perfectly absurd, that it was all a matter of efficient time management. When it came to the actual hearing, they didn't put in any evidence at all. So the Supreme Court was able to say, well, they have to have a good reason, and they haven't put forward any reason, so they lose. And I believe that they were given what I would regard as the correct advice, but rejected it because it would have been inconsistent with some of the public statements that had emerged from Number 10. I haven't got cast iron evidence for that, but I think that it is so.
Advice from their lawyers?
I think that I would be astonished if the English and Scottish law officers had not advised them that that was the right course to take. It would also, in all probability, have been the truthful course to take. So
given that they didn't, it's not really a surprise
I'm sure that's one reason why it was unanimous. Unfortunately, I think that that particular ground of decision is rather difficult to justify. Because if you say that you can't prorogue except when there's good reason, what happens if the next time they do put forward a reason? It's almost certain to be a political reason, like the reason that I think that they should, if they'd been truthful, have offered to the court. How is the court going to resolve that? It will inevitably end up by having to decide whether an essentially political judgment is a reasonable one or not. I think it would be very unfortunate if the courts were to make a decision like that. And I'm sure that they would run a mile without doing it. They didn't have to because of the government's mishandling of Gina Miller number 2. But they might have done, and they might do next time. It would have been much more satisfactory, I think, to say that if the government had won that case, it would have left a serious constitutional void. It would have meant that a public power, which is what the prorogation power is, would have been exercised without the government being answerable to anybody. Not to Parliament, because it would have been prorogued, not to the electorate, because there was not to be an election for another 3 years or so, not to the monarch, because by convention the monarch's prerogative powers are exercised by her ministers. So what you would have done is to transform a public power of the Prime Minister into a private privilege. I think that the common law has never accepted that a public power can be exercised entirely without constitutional responsibility to anyone at all.
So it was a right ruling, in your view, by the court and held the executive.
I've got misgivings about the reason, because the reason was only relevant in that particular case. And in another case, the government will probably get its ducks in a row rather more skillfully than they did last time.
I mean, one strange feature of it was the overruling of the Lord Chief Justice himself in that case. Was he wrong?
I think so. Because I think the answer was pretty obvious, given the way the government conducted the case.
Can I take you back now to your early life in the bar? Why did you, and tell me a little bit about where you grew up, and I know where you went to school. You went to Eton and you went to Magdalen College. Where did you grow up, and did you have law in the family? No. My father had been a solicitor after he was demobilised at the end of the war. Where did he practice?
He practiced in London in a small niche firm where he took over from 2 elderly partners who wanted to retire. So he was effectively a sole practitioner, but then took on a few partners. But he stopped being a solicitor in the early 1950s and went into a form of investment banking. And that was reasonably successful for a while, but then spectacularly crashed, and my father was, I think, pretty lucky to get out with his shirt still on his back. So that wasn't an influence. His going into law or being in the law wasn't an influence. Well, my father then went back into law because after his business had basically collapsed, he read for the bar and became a specialist in tax. And he practiced at the bar for nearly a decade before definitively retiring. So he had 2 phases of law. So you did have some insight into Yes, but by then, the world. By the time he became a barrister, I was in my 20s and intent on other things. You read history. Yes. And what encouraged you then to leave and become a barrister? Or to well, the honest answer to that is that it was the money. I didn't want to be enormously rich, but I did want to be a bit better off than a junior academic, even at a wonderful university like Oxford. I can think of better reasons, but they're all afterthoughts. So you obviously had a very successful career at the bar, and moving swiftly then to your decision to go onto the bench. Why did you make that decision? Well, I had in fact declined to go to accept appointment to the High Court on a number of occasions. That was because I felt that I was very much enjoying practising at the bar at the level at which I was practising, I didn't find very attractive the prospect of going down to the bottom of another ladder and then finding myself hearing a lot of cases which I wouldn't have touched with a barge pole as a barrister. Now, that may be rather a selfish view, but I mean, inevitably, career choices are ultimately choices about what one's going to enjoy doing, because if you don't enjoy doing it, the chances are you won't do it very well. Then I got a broad hint that an application for the Supreme Court would be not, they didn't say welcomed, but certainly
looked on favourably,
taken seriously. So I decided to apply. As a matter of fact, I very nearly missed the deadline because I'm not an assiduous watcher of the Sitzvac columns in the newspapers. It was only when I bumped into one of the administrators at the then prospective Supreme Court, who said that they were rather surprised that somebody in my chambers had applied for the application documents, who seemed to be unaware that he was well over the retirement age. This, of course, was Sidney Kentridge. And the secret was, and he came into my room, this was the day before the deadline, and said effectively, sign here. Otherwise, I would have missed it.
You would have missed it. In fact, it wasn't a completely straightforward thing, was it, as I recall? There was quite a lot of controversy about it. Yeah. There was a little bit of toing and froing behind the scenes. There was a lot of opposition among Court of Appeal judges.
Well, I applied twice.
You applied twice, yes.
And the first time, I was told that I would be selected, but the Court of Appeal cut up rough, and no announcement had ever been made, so that was fine. The exercise was rerun, and I wasn't even shortlisted the second time. I don't think they wanted a repetition of the previous row. So that was fine. I mean, it did a lot of damage to my practice because the publicity associated with it when the news leaked out that I'd applied basically meant that people stopped instructing me. So as soon as I realized that I wasn't going to be selected on the rerun, I made a public announcement that I was withdrawing, because that was the only way that I was going to salve my practice.
Yes.
Some time later, in fact, nearly 2 years later, it was suggested to me that I might want to apply again. And I asked whether they were actually seriously prepared to entertain an application from somebody who wasn't an existing judge, because I saw no point in applying again if the policy was that they were not going to accept somebody who wasn't already in the Court of Appeal. Anyway, I formed the view that the atmosphere had changed. I applied, and we know what happened.
Well, it broke new ground. And did you encounter much hostility then from people? Were colleagues resentful?
Absolutely not.
That you came in directly from the bar?
I received absolutely no hostility whatever from within the Supreme Court. And I actually had some very reassuring statements from some of the people who had been hostile to my appointment 2 years earlier. And so that passed, without really any difficulty at all. As I got into my stride in the Supreme Court and started writing my share of the judgments, I think people broadly accepted that this was fine.
You had a contribution to make. And how did you enjoy it? It's obviously extremely different from the work you'd been doing.
It's the best judicial job in the world, or at least in the British world. The Supreme Court enjoys uniquely favourable conditions for writing seriously considered judgments. We are not placed under pressure of time. We are able much more easily than Court of Appeal judges or puisne judges to say, I need longer to do this, or I need more time away from hearings to do this. It's a court whose administration is basically controlled by the judges themselves. So it works extremely well. It also works at another level because it's a highly deliberative court. We don't, as was once the practice, certainly before the Supreme Court was created, we don't simply hand down our judgments like tablets of Moses and discover, rather to our surprise, whether we are in a minority or a majority. We exchange drafts, we comment on each other's drafts, we negotiate compromises in order to produce the best possible consensus. It's very deliberative. And that, I think, is very much in the public interest.
Did you get into any serious tussles with any of your colleagues over any particular decisions?
Well, I'm not going to disclose which ones, but certainly there were cases in which, there were very few cases in which tempers rose, though there were one or two.
Did you have to back down in your views on anything?
Oh, I frequently did that. It would be, I think I can only remember one case in which I actually changed the way that I voted as a result of discussions or drafts from other colleagues. But it was very common to find that one could express something better or that there were better reasons than the ones one had given. And you have to be prepared to take into account other people's views, not only because their views might actually be more logically compelling than the one that you had first arrived at. You also have to do it because arguing about the finer points of the reasoning between people who basically have arrived at the same conclusion is rather unproductive. It muddies the waters and leads to unclear judgments. And I think that is against the public interest, so that there is another reason for endeavouring to conform one's view as far as possible to those of colleagues who basically have arrived at the same ultimate conclusion, whether it should be yes or no.
Do you feel, looking at your two careers, if I can put it like that, where do you think you had most influence as a highly successful advocate, bringing a very large number and winning them of leading cases?
I lost cases too.
Oh, you did, I'm sure. Or on the Supreme Court as a very influential justice. Where do you think you had most influence?
Obviously one has more influence over the results of decisions in which one is sitting, even if one is only 20% of the panel deciding the case. I think that good advocacy rarely wins cases, but bad advocacy frequently loses them. The impact of good advocacy is basically to draw the court's attention to the best that can be said for a particular point of view, to ensure that things are not overlooked. But ultimately, I have enough respect for the quality of the judiciary in this country to believe that the result would have been the same, whether one had been a good advocate or a mediocre one.
Well, I think you're being very modest. They're going to be persuaded by good advocacy, I'm sure, like anybody else. Can I ask you, you've spoken quite a bit, not least in your Reith lectures, about the vacuum that the courts have filled to some extent by politicians not necessarily being bold enough to take decisions in controversial social areas and others. Tell me a bit about that. Do you think the Supreme Court has become too political?
No, I don't think it's political at all. I think that judges often start with a certain instinct. It's a social instinct rather than a political instinct about fairness and the way that, for example, minorities should be treated. And there's a long liberal tradition in the English judiciary, which is not at all recent. It goes back very, very many years. But that doesn't amount to political decision-making. All judges start from a hypothesis about what their instinctive answer would be, but you then test it against the facts, you test it against the legal principles, you test it against logical coherence. And if you find that your hypothesis starts getting a bit battered, you change your mind. That's how it works. Nobody starts from a blank sheet of paper, but they end up in the best place, I think, by being prepared to be rigorous about their initial instincts.
I suppose what I mean more is, are they taking decisions of a political nature that they should not really be taking?
I think that there have been cases like that, and I spoke about this on this subject in my Reith lectures. I think that there were decisions like the decision about the Prince of Wales's letters, for example, which I found extremely difficult.
Shall we just say what that decision was, to release the letters that had been confidential?
Yes, I mean, the Act clearly stated that the Secretary of State or the Attorney General had a veto, and we know that this was politically what was intended because the way that it passed through Parliament. But the courts have always been extremely suspicious of any attempt to confer on a minister or an administrator a power which they think should belong to them. And there has been a tendency, another example I think was Privacy International, a decision about whether you could judicially review certain decisions of the Special Immigration Appeal Tribunal. I think that was very difficult to justify. I dissented. But these are not political decisions. These are basically decisions in which the court is defending what it regards as the jurisdiction it ought to have, even if statute has said it doesn't. And I don't approve of that. And as I said, certainly in the Privacy International case, I wasn't sitting on the Prince of Wales letters case. But naturally I had views about it. But these aren't really political decisions. There have been other cases in which I think that judicial activism had gone too far. But I think that there's always, in the way that courts work, a movement to and fro, a process of action and reaction. And at the moment, I think that the Supreme Court has done an extremely good job in checking these tendencies. Just in the last year and a half to 2 years, there have been two important Supreme Court cases, one involving Shamima Begum and the other a decision about the Child Poverty Action Group's action involving the decisions about Social Security payments. In both of those cases, the Supreme Court emphasized that there are many things which in a democracy ministers have to be responsible to Parliament for. They cannot be responsible to the courts without cutting across lines of responsibility which in a constitutional democracy are very fundamental. That's a principle which I think the courts had tended to lose sight of. And I think at the moment what we are seeing is a valuable corrective to the previous enthusiasm of courts for interfering with political judgments.
You think it's gone back a little?
I think it's gone back to more or less the right place.
So the current balance between the judiciary, the executive and Parliament, a delicate balance, would you say it's about right?
I think it is about right now. I think that at the time when I left the Supreme Court, the balance was too hostile to the executive. And I think that the corrective is therefore valuable. It has, of course, caused howls of objection.
When you say the balance was too hostile to the executive, you mean the judges tended to make rulings which were too critical of the executive?
Yes.
They did it too frequently, or they... They
did it too frequently and on issues which essentially involved political judgments of the kind of which the courts are not the proper arbiters.
Have you got a particular case in mind you can cite?
I would want to choose my cases rather more carefully than I can do in an informal interview like this. But I certainly think that although the courts for example, the Prince of Wales letters case, were concerned mainly not with the political aspect of it, but with the constitutional implications of making a minister the judge of the public interest, it seems to me that that was a case in which the court was too hostile to the executive, maybe for non-political reasons, but nonetheless too hostile. There are lots of cases in which a minister is a better judge of the public interest than a judge. I'm not suggesting by any means that all cases are like that, but very many are, and that may be because the executive has a far wider range of information available to it than the special interest groups who tend to get involved in public law litigation. Or it may be because ministers are responsible to Parliament for their judgments of the public interest and can be thrown out if they get it badly wrong.
Yes. Do you think you're unusual, though? I think you are, aren't you? A bit of an outlier in your attitude to the executive compared with some of your former colleagues.
Well, it's not actually an attitude to the executive. I've expressed it in terms of hostility to the executive, but my prime concern is not with protecting the executive, but with protecting the role of Parliament as the body to which ministers are properly accountable for most of their decisions. It seems to me that the role of Parliament is fundamental in any democracy, but particularly in a democracy like ours, in which we do not have directly elected heads of government or heads of state, and Parliament is the essential sounding board for all public policy.
Have we seen a change in attitude in recent years within the executive to the parliamentary process or indeed the rule of law?
Well, the rule of law is too elastic a concept for me to be able to answer that question without a lot more precision.
I was going to actually ask you to summarise the rule of law, but that's probably impossible.
Well, but anyway.
The attitude of ministers to parliamentary process, the rule of law generally.
I think that during Boris Johnson's prime ministership, there was a contempt for Parliament, which was very unfortunate. It was summed up in the statement which Geoffrey Cox, in many ways an extremely responsible and moderate lawyer when he was Attorney General. But you may remember that in September 2019, he solemnly told the House of Commons that they had no right to be sitting there because they were getting in the way of the government's negotiating policy about Brexit. Now, whatever you think about Brexit, the suggestion that MPs it's none of the business of MPs to hold the government to account for the way they conduct the negotiations was frankly utterly ridiculous. I think that Boris Johnson did have a contempt for Parliament. He did feel that he had a personal mandate, which is not the constitutional doctrine. He may have been a large part of the reason why the Tories won a large majority in December 2019, but that does not mean that the mandate is to him, as opposed to the general body of MPs to whom he was responsible. We saw this again when, within hours before he ultimately was forced to resign, he started complaining that, given his personal mandate, it was completely outrageous for MPs to get rid of him. I think that the test of a democracy, functional democracy, and particularly a functional parliamentary democracy, is not whether it stops complete charlatans from getting to the top.
Are you saying he is a complete charlatan?
Yes. I think the test is whether it enables them to get rid of him once the mistakes are discovered.
And it did.
It did, as it did with his successor. I think that is parliamentary government at work. We don't have a presidential system. If we did have a presidential system, we would need a lot more checks and balances, which we lack precisely because we have a parliamentary system.
One of the fallouts from Brexit is ministers looking repeatedly at the European Convention of Human Rights and whether we should come out of it. What's your view about that?
Well, I've expressed my view that we should come out of it. It's a view that I've come to recently and reluctantly. But I think the first point to make is that the ECHR issue and the European Union issue are completely different. The European Union is a classic example of an arrangement by treaty under which sovereign states collaborate to do something which they are not capable of doing individually. In that case, creating one of the largest single markets in the world. Now, you might or might not think that that was a sufficient advantage to justify the ceding of sovereignty involved. I'm not going to get into that. But that is the reason why you normally enter into a multilateral treaty. The ECHR is completely different. The ECHR is a treaty governing the contents of our domestic law. Everything that is in the ECHR we can do legislatively ourselves with no cooperation at all.
And we should do, in your opinion?
I think that we should do certainly now. The problem, I think it's very important how we do it. I would not be in favour of leaving the ECHR unless we substituted for it something which was functionally equivalent, except that it would not be subject to the jurisdiction of the Strasbourg Court.
A British Bill of Rights?
Exactly. That is what I think we should aim for. This is a minority position in England, I have no doubt about that. But that's because people say to themselves, do I like this, that or the other decision of the Strasbourg Court? And many of them are perfectly admirable decisions. But that's not the issue. The issue is, how should one make law for a democracy? And the problem about the Strasbourg Court is that it has, since the 1970s, emancipated itself from the text of the Convention, which is the only thing that the states have ever agreed, and given itself a roving brief over large parts of the whole range of social policy in respects which are not covered by the Convention. It may well be that the Convention needs to be updated, but it isn't the function of a judge to update it. It's the function of politicians and statesmen in the countries of the Council of Europe. If you have an institution which ignores the mandate, the limited mandate given to it by the states, and cuts across the demarcation line, the lines of responsibility essential to a democracy, I think that you should pause and ask yourself whether this is a sensible way to behave. I've only recently come to the view that we should actually take the extreme step of leaving it. But I really don't see that the Strasbourg Court, which is a very ideological court, is going to reform itself. I once thought that there was some prospect of that, but I've given up on them.
Well, as we speak, the Supreme Court is looking at the government's appeal over removing illegal asylum seekers to Rwanda. We don't know which way they're going to rule. Have you got a view on that? What do you think they should decide?
I don't have a view on what they should decide because there's very little law in it. It's essentially a question of fact. The issue is whether Rwanda is safe or not. There's a very large volume of evidence before the court, and I haven't read that evidence, so I am not going to pronounce on what the result might be. I would have every confidence that whatever the result, it will be soundly based on the evidence.
It might find the Supreme Court justices once again under attack or criticism from certain quarters of the public or press, as they were previously in the Gina Miller case. Well, what do you feel about that? I mean, do you think the public doesn't really understand what the judges are seeking to do, or?
I think any member of the public who wants to understand what the Supreme Court is doing or trying to do, it can do so. I think one of the striking things about Gina Miller #1 is that the famous Daily Mail headline, Enemies of the People, was about the Divisional Court's decision, from which the appeal lay to the Supreme Court. Nothing equivalent happened after that. Now, I don't think this was because the headline writers in the Daily Mail suddenly had an access of conscience or rethought their position. I think the main reason for it was that the proceedings were televised. Anybody who chose to tune in, and there were, of course, extracts on the news and in some extended news coverage programs. Anybody who wanted to tune in would have found that whereas he might have been expecting impassioned political declarations, what he actually found was there we were sitting, grinding through cases decided in 1916 about crown leases in wartime.
Very dry.
But absolutely, and that's how it should be.
Yes.
That's an issue of law.
Yes. So do you think?
And I think that the televising of the proceedings has made an enormous difference to the public reception of judicial decisions.
That's what I wanted to ask you. Yeah. And you think it's a good? Obviously, it's a good thing.
I think it's the main reason why most people, in fact, accepted the decision in Gina Miller number 1. They were much better informed on the subject, and that's as it should be.
You're in favour of televising court proceedings, are you?
Yes.
In general?
I wouldn't want to televise all court proceedings, but court proceedings in appellate courts about questions of law, I think that there's everything to be said for televising them, but particularly, we don't want wall-to-wall coverage of court proceedings. People are entitled to be entertained, and that's not the best way of being entertained. But I think that there's a strong case for televising the proceedings of the top court and very possibly of the Court of Appeal as well. I would not want to see televising of witness evidence. I think the experience of televising US criminal proceedings, O.J. Simpson is an obvious example, suggests that it has a very damaging effect, both on the impression that it gives to the public, because it gives the impression that this is actually essentially a sort of formalized lynch mob, which it isn't. And because I think that witnesses who are being televised, and in particular barristers who are being televised, behave in a way that is slightly different and rather less helpful.
We now have, of course, a woman Lord Chief Justice. You got into a bit of trouble a few years ago, suggesting it would take 50 years, I think, before we had proper diversity and equality on the bench.
Yes. Well, when you say I got into a bit of trouble, you mean people disagreed?
They disagreed loudly.
Okay.
Have you changed your view? I mean, what difference will it make, if any, having a woman at the helm of the judiciary?
Well, the Chief Justice doesn't, of course, choose judges. I mean, the first thing you've got to realise is that even if you ensured that, say, 50% of judges were women every time there was a selection process at the Judicial Appointments Commission, it would take quite a few years to produce 50% of the judiciary being women. So mere mathematics is going to ensure that it's going to take at least 20 years. There is a serious problem, as I tried to point out, about the high dropout rate of women from the legal professions, which is the source, of course, from which judges are appointed. For some time now, women have been at least 50% of the recruits, and actually rather more than 50% of the recruits, to both the solicitor's profession and the bar. When you look, however, at the most senior levels, at QCs and at candidates for appointment to the bench, the proportion of women is much lower. Now, if you look at the appointments of judges to the circuit bench or the tribunals, the diversity picture is actually rather good. The proportion of women is pretty high. The higher you go, up the judicial hierarchy to the appellate courts, the high courts, and the Supreme Court, the less satisfactory the position appears to be. But the reason for that is that these people are being selected from the top levels of a profession which has an extremely high dropout rate for women. And that is not going to change because it's in a hurry. The reason being that it's actually dependent on really profound societal habits that die very slowly. For example, the willingness of married couples to share childcare duties equally. That is something that will make much more difference to the availability of suitable women to appoint as judges than any other single thing that I can think of. Yet it's completely unamenable to administrative or legislative control. We are moving there. And actually, I think we are probably moving there faster than I envisaged when, as you say, I got into trouble. But, it's still going to take time. You cannot take really profound societal changes like the one that we have experienced over 70 years or so on the role of women in public life and expect to turn up with a magic bullet and solve the problem straight away. That was all that I was seeking to point out. Yes. So the brouhaha was really a bit absurd.
Finally, then, just a couple of questions. We touched on the balance of power between the arms of the Constitution, and I think you said you thought it was about right.
At the moment, I do think that.
Is it for the future? Is it something you fear might be at risk? I know we're not going to ever be, hopefully, going down the Israeli route of the government wanting to determine judicial appointments, but are there risks that our Constitution faces?
And the reason why there are risks is that all constitutions, and particularly informal constitutions like ours, depend to a very large extent on a culture of respect, not just for the letter of the law, but for the spirit of the Constitution, a desire to make things, a feeling that for the system to work is more important than to win on any one issue. I think that culture took a knock during the Johnson prime ministership. And I think that things have improved a great deal since then. But because our constitutional norms are so sensitive to cultural changes, there is always a risk that things might change for the worse. I don't actually think that it will happen, at any rate, anytime soon, because I think that what we have witnessed in the last few years is actually a vindication of the notion that constitutional values really do matter, and that politicians, however senior, who ignore them, lose their jobs.
And more globally, I do think there's a worry about liberal democracy across the world.
Yes, I do. I think it will probably survive, but I think that the main problems faced by liberal democracy are a growing intolerance of dissent. And without dissent, there is frankly no truth, because truth emerges from a conflict of ideas and not from an imposition of ideas by one or other side in a particular debate. I think that is the main challenge to democracy. It's particularly significant because the mood that I've described is strongest among the young, who are the generation that is currently taking over. And that is a serious problem. I have to say that I think that the situation is much worse in the United States than it is here, but it's not a happy situation in either place.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.